Ready, start. The orders dated 26/10/2019 and 27/12/2019 were set aside and the case was remanded to the court below to grant an opportunity of hearing to the parties concerned to decide the case afresh on merits. Full stop. It is against the aforestated order dated 18/11/2022 passed by the Commissioner that the present petition has been filed, wherein an objection has been raised on behalf of the private respondents with regard to entertainability of the petition by pointing out that against the order passed in appeal, the petitioner would have an efficacious statutory remedy of filing a revision. Full stop. The argument sought to be raised on behalf of the petitioner to refute the aforestated preliminary objection is that the remand order is without any observation on merits, and therefore, the same is a remand simpliciter close, and the order being of an interlocutory nature, a revision thereagainst would not be maintainable. Full stop. In order to test the aforesaid argument, the order passed in appeal would be required to be examined. Full stop. The order passed by the Commissioner while exercising appellate powers takes notice of the fact that the court below has rejected the restoration application filed by respondent number 6 by making observations on merits. Full stop. The appellate court has also taken notice of the fact that the registered sale deed which was available on the record of the case was indicative of the fact that the land in question was not the ancestral property of the parties. Full stop. But the same had been purchased by both the parties from the original tenure holder by means of registered sale deeds, showing separate boundaries. Full stop. The appellate court, after discussing the findings returned by the court below, has held the same to be legally unsustainable. Full stop. Further, since the court below had decreed the suit ex parte without granting opportunity of hearing and adducing evidence to the parties, the case has been remanded with a direction to the court below to pass a fresh order after giving due opportunity of hearing to the parties concerned. Full stop. The remand order passed by the Commissioner, thus, containing a detailed consideration on merits of the case and thereafter recording a conclusion that the findings returned by the court below, were legally unsustainable, cannot be held to be remand simpliciter close. Full stop. The decision in the case of Ram Bhajan and others Supra, which is sought to be relied upon on behalf of the petitioner, thus, would not be applicable in the facts of the case. Full stop. Moreover, the said judgment cannot be held to be good law in light of the subsequent division bench decision of this court in Dinanath and others Supra, wherein while deciding the reference on the point, it was held that an order passed in appeal under section 11 of the UP Consolidation of Holdings Act, 1953, by the settlement officer consolidation close, deciding the appeal finally by setting aside the order of consolidation officer and remanding the matter would not be an interlocutory order, and the revision against the said order would not be barred. Full stop. The order of remand, in the present case, in terms of which the case has been remanded after making certain observations on the merits of the case, and issuing directions to the court below to grant the parties opportunity of hearing and of adducing evidence, cannot be held to be a remand simpliciter close, or an order of an interlocutory nature close. Full stop. This is more so since the order passed by the Commissioner has a finality attached to it in the sense that it has the effect of disposing of the appeal. Full stop. The order was passed by the Commissioner erroneously. Full stop.